But let's talk about some things that are interesting and some 3 rules of asset protection as we go along. So the first rule in asset protection, I want you all to remember this, is critical today, that asset protection planning that's done after the fact is really not effective. No, you laugh, okay? But we understand, hey, we're driving down the freeway, God forbid we have a bad automobile accident, people are seriously injured, and guess what? We better call the insurance agent and say, oh my God, we don't have enough umbrella liability insurance, can we increase it? We wouldn't do that. Same thing, we have a rental property, all right? And the carbon monoxide detector failed, and a mother and a child were killed in your rental property. It happened. Cases, we've seen them, we've had them. It's not a great time to call the insurance company and see whether or not we have enough insurance for it, and whether or not it's even an insured event. Because maybe we were grossly negligent. Maybe there was strict liability by code that we had to have a working carbon monoxide detector and we didn't. Or mold, the famous one that's coming up. So we have issues that go all along the way. So number one, after the fact doesn't work, we will get calls after the fact. That's when you're motivated. But it works when you're not motivated. The second thing that you need to know, and I don't know where this comes from, but it comes from somewhere, that living revocable trust, the trust that we have for estate planning, avoiding probate, well, it provides 0 asset protection. People say to me, well, I have my rental property in my trust, or I have my house in the trust. It's protected, right, on my bank account? The answer is no. If you can reach the asset, then the creditor can reach the asset. So that's the second kind of axiom before I get to some specifics. And the third and the last axiom that's really important to understand is you say, hey, I got insurance for that. All right? I have insurance on top of insurance on top of insurance, so I feel really good, it's insured. So when people come to my office and they, oh, I have landlord-tenant or I have an umbrella, it's $1 million or $2 million. What they're really doing is they're sticking out their chest and saying, we don't believe that we will ever get a judgment that's in excess of the amount of insurance that we have. So I have $5 million. That's it, I'm safe at 5. There is no relationship, ladies and gentlemen. If you had that carbon monoxide failure in that particular rental property and you had $2 million worth of coverage, believe me, it's $10 million. There's no relationship. So we may always get a judgment that's in excess of the insurance that we have. So insurance is very, very, very important, but it's not the know-all, end-all. The other thing that happens is that, do you ever hear of the term exemplary damages, special damages, or punitive damages? So if as a landlord, or as an individual, or as an entity, we're considered to be grossly negligent, and remember, it's just 12 people determine gross negligence. What's the difference between negligence and gross negligence? It may open the door for punitive damages, especially in California. And if we have punitive damages, how much do you think our insurance is paying for that? 0. Because it wouldn't be punitive if Allstate was paying it for it. It says, how much money do you have? We want to take away 60 to 70% of it. So what we really need to do is to recognize that there are other things that we need to do.